All right. Good morning, everyone. I'm going to start. I have a co-panelist, it's Director Rochelle Ford, here with me this morning. Before I get into housekeeping, can everyone hear me okay? If there's anybody that can't hear me, let me know. You can put it in the chat. Okay, I got one yes, so I'll just go with that. All right, so a few housekeeping rules, and then I'll just quickly explain what the presentation is going to look like this morning. The first thing is that Director Ford thought that this presentation would benefit from having you all be able to discuss and see each other. If you want to turn your camera on, feel free to do so. If not, that's fine as well. But she thought that it would be good if we could see each other and also be able to discuss. So you are able to unmute yourself. Be extremely mindful of that. Be mindful of mistakenly unmuting yourself, background noise, those kinds of things. But if you want to chime in, if you have an answer to one of our questions or something like that, feel free to go ahead and jump into the discussion. So today's presentation is essentially going to be a discussion of seeking and negotiating employment with private sector companies when you're leaving the district government, or even if, potentially you might be staying and you want to have some outside employment with a private sector company, and then post-employment. Those two bits of subject matter are closely related. We see them as closely related in our agency, so that's why this is a combined presentation of the two topics. So essentially, the first part of the presentation is going to be presenting you with the rules surrounding seeking and negotiating employment, and then the rules surrounding post-employment. And then the second part of the presentation is going to be 4 hypothetical questions where we kind of put some, fake names and faces to the rules because we think that post-employment and negotiating is a little bit more easy to digest when you do it in hypotheticals. So let's get started. Director Ford, did you have anything to add?
Hello, Asia.
Hi.
Hi, sorry, I had a little technical problem. Are you all able to see me yet? I don't see myself yet. Hold on.
We can't see you.
How about now?
Yes, now.
Great. Awesome. Good morning. Thank you for introducing today's presentation. I'm really excited to have you all here. I think this is a great time to discuss this topic. It's been obviously something that's been front and center in terms of public ethics this year. So we want to take this time to answer your questions and give you a sense of what some best practices and some tips are as you assist your colleagues or yourself considering potentially either outside employment or future employment. Okay. And so, Asia, am I to go ahead and start talking about just the rules in general?
Yeah, you can go ahead, and I think you have to signal to Ashley when you're ready for the next slide.
Okay. Next slide, please. So first, we're going to talk about the rules. They're pretty straightforward. It's just that because we are in the District of Columbia, we are subject to a rule within the DPM, as well as the conflicts statutory rule. And then as public officials and employees of DC, we are also subject to the federal statute with respect to conflicts of interest. So all of the rules with respect to employment, whether you're looking for it or actively, are ultimately about a conflict, right? They're about using our position and our power and our the work that we do to influence or to benefit a private entity or ourselves. But I think more importantly, it's about the appearance of that. And so what we hope to do after today's session is talk about ways to get out the message that it's not just about formalistically following the rules. We want to give you, although we want to give you those sort of guideposts, but also about erring on the side of caution because the appearance, undermines public credibility in some ways. And also it's unfair to prospective or to the employees who depart because it puts a cloud over their work potentially because of an appearance that could have been avoided with a little more caution. So that's where I would start with the rules. Next slide, please. So the main rule that we all are covered by is in the DPM, and that is employees shall not engage in outside employment or activity, including seeking, this is important, or negotiating for employment that conflict with their official government duties and responsibilities. So there's a general prohibition that if you are looking for work, whether that be outside work in addition to your district job, or you are looking for a future job, that you in no way work on matters or engage in matters that could impact those prospective employers. Next slide, please. So I think this is a good time to talk about what seeking and negotiating are here, because the terms have both common sense, I think, meaning, but they have important legal meaning for all of us. And this is why this is a good place for us to talk about why being cautious is important. So an employee is seeking once they have directly or indirectly, sought out or received an unsolicited offer for potential employment, whether that be from someone from a company, an individual, or from an intermediary. And so that someone says, hey, Asia, it's been great working with you. We would love to have you come work over here with us. If Asia doesn't say, thank you very much, but I'm not interested, I love my job at OGE, and I hope she says that, then she has clearly rejected the offer. That's why it says any response other than a rejection. If she says, I'm too busy right now to think about it, I'm flattered, she has not rejected. So it's very important to recognize that seeking can be unilateral. It could be someone reaching out to you, or it could be I'll use Asia as the example here since she's here, and say Asia has always been really passionate about animal rights. And she just happens to be seated at a dinner one night next to someone who has found the perfect animal rights job for her. And, not a good, she doesn't relate to what we do here outside the district. But I would love to come work with you. Let me know. It's far-fetched. She is now seeking with that animal rights interest group, unless she says, hey, you know what, never mind, I'm working at the district. So I think it's important because, seeking is sensitive, is what I like to say, because, it's uncomfortable to tell your current employee that your employer that you're looking for work. And in some places, it might not even be a good career decision. I think, we would be disingenuous to not acknowledge that that's a concern for employees. But we also want to be aware that once we begin to look, we have that appearance of a prospective interest. So while it's pending, even if no one ever calls you back because you sent that out, that undermines the credibility of your work. Negotiations and contracts and contrast, means discussions or communications with another person that are mutually conducted with a view towards an agreement regarding possible employment with that person, but it's not limited to the discussions of the specific terms and conditions of employment. So a couple of things. Going back to my example, they called up Asia. They told her she was great. They'd love to have her come on. And she says, hey, you know what? I would love to talk with you about that. And she immediately recuses from working on that matter because both negotiation and seeking require a recusal, right? She wants to talk to us. So she shouldn't work on matters while she has that pending possible financial interest. So she immediately lets someone know, just so you know, I'm going to go and talk to so-and-so. And she sits down and they have coffee and they have a lot of common interest. And the person says, what would it take to get you over here? Well, they're not talking about a specific number, but now they're thinking they're talking about salary. They're now mutually working. It's not just bilateral, as in I'm seeking out or someone sought me. It's now mutual. We've expressed interest in moving forward with each other. So it's not that there's some magic words, and it can be a confusing question. And so I think, as you think about communicating this to your colleagues and other employees in the agency, because at some point, everyone should know that you may seek employment and you want to do it well, and so people want to come to you, that's that distinction. Anyway, next slide, please. The conflicts of interest rule in D.C., it is codified here, and it's that no employee shall use their official position to substantially participate in a particular matter or attempt to influence the outcome of that matter if they know they have a direct and predictable effect on their self-interest, financial interest, or a person that's closely affiliated with that employee. When you enter into a relationship, you begin seeking. You're now under the district DPM, rather the code of conduct. You are now closely affiliated. So if you're seeking with an entity, that entity is an entity that you are closely affiliated with. So under the district rule, you can't act on matters if you're seeking or negotiating. Next slide, please. So this is 18 U.S. Code Section 208, and it's the criminal statute. And although on some matters for example, we don't follow the federal standards of conduct, although we look to them for guidance, and that's part of if you look at our precedent and our advisory opinions, you can see that we look to them for guidance on issues like this. And so 18 U.S. Code Section 208 is the federal conflict of interest statute. It's very similar in terms of, what the limitation means. It's just more explicit about negotiation. So note that all officers and employees of the District of Columbia, so all of us, could violate 208 potentially, so because of where we work. And again, we are prohibited from personally and substantially taking part in a particular matter that could have an outcome on the financial interest of an entity. In this case, it's explicit, or any person or organization with whom he or she is negotiating or has any arrangement concerning prospective employment. So they're saying if you have an arrangement, you've hit that bilateral place. If you are in negotiations or have actually come to an agreement, at that point you have a financial interest, and if you acted, you violated the law. And so OGE's guidance overall is to advise people to be very cautious and to recuse at the seeking stage as a prophylactic measure to never enter into the negotiation stage, because then you've broken the law. Although there's a waiver process with respect to the federal government, we don't have that here. So those are the laws and the rules that relate to seeking and negotiating. I think, the takeaway is that you want to, I think, either at the outset of things or at some point, on an annual basis, make it known to people that, hey, I know people look for jobs. Just remember, ethics is here. Here's some things to think about. So I'm going to turn it over to Asia to discuss the post-employment rules with you.
Thank you, Director Ford. So I'm going to briefly discuss the post-employment rules. As you'll see as we go along in these slides, the post-employment rules are dense, and to a certain extent they can be extremely nuanced. So I'm going to give a brief overview, and hopefully through our discussion and the hypotheticals we'll get a better understanding of the rules. So the first one, there's three general prohibitions. The first one is the permanent prohibition, and it essentially says that any former government employee is permanently prohibited from acting as a representative in any formal or informal appearance before the district as to a particular government matter, including a specific party, if the employee participated personally and substantially in that matter as a government employee. You're prohibited from appearing before an agency, which would be the former employee's former agency. So what this is essentially saying is that if you participated in a matter as a district government employee, and you worked on that matter, and you were the point person on that matter, you'd be prohibited from going to a private sector company and working on that project on behalf of that company, and then, drafting some sort of report, and then submitting and presenting that report to the district government regarding the same particular matter that you participated substantially in. And then 1811.4, it says that you are permanently prohibited from making any oral or written communication to an agency with the intent to influence the agency on behalf of another person as to that particular matter. That's kind of roped into my general example. You know, you shouldn't be drafting the report, you shouldn't be submitting the report to the district, and you certainly shouldn't be going to the district and presenting that report. Um, and so the permanent prohibition is the most restrictive prohibition. It is generally reserved for, you know, you'd be fairly certain if it was a matter that you participated personally and substantially in. It's something that it'd be a project or a matter that you knew a lot about. Again, you'd be the point person. You worked on it substantially. You knew the ins and outs of that matter. And just by nature of having had been that involved in the matter, we don't want you to be able to use any unfair advantage and come back to the district and maybe you know, potentially work against the district interests and working on behalf of this private sector company with information that you glean from working with the district on the matter. Next slide, please. All right, so the reason that the post-employment 2-year prohibition slide has a section header slide is because this is actually the most dense rule. It has the most subsections in the DPM. So I'll try to be as brief as possible as I'm reviewing the subsections of this rule. Next slide, please. All right, so first subsection is DPM section 1811.5. It says that a former government employee shall be prohibited for 2 years, and that's after terminating your district government employment, from knowingly acting as an attorney, agent, or representative in any formal or informal matter. And if you'll notice, that's kind of the same language from the permanent prohibition. The difference here is that the prohibition would only apply if you previously had official responsibility for the matter. And so the difference here is going to be with the permanent ban, it would have been something that you were knee deep into, that you were the point person on. With the 2-year ban, it may be something that you had essentially cursory responsibility before. You signed off on matters. You received briefings and updates from others on the matter. Even though you may not have been personally and substantially involved in the matter, you had official responsibility for the matter. And that is where the 2-year prohibition will come in. Next slide, please. All right, and so subsection 1811.6 is essentially some of the subsections give us, time frames and structures for the rules so we can understand how the rules work and at what points they would apply. It essentially says that a matter for which the former government employee had official responsibility is any matter that was actually pending under the former employee's responsibility within a period of 1 year before the termination of such responsibility. So if you worked at an agency for 6 years, it doesn't make much sense for us to apply the 2-year ban once you left to something that you worked on for 6 months in your first year at the agency. So this would only be a matter that was pending under your responsibility within 1 year of you leaving the agency. Next slide, please. All right. Again, another basically yardstick time structure for the rules. This one says that the 2-year restrictive period in subsection 1811.5 of the section shall be measured from the date when the former employee's responsibility for a particular matter ends, not from the termination of government service, unless the two occur simultaneously. So essentially what this rule is saying is that whatever this matter that you had official responsibility over, the 2 years will start from when your responsibility for that matter ceased. So if you have official responsibility over a project, but maybe the project ended, it wrapped up, or maybe you were moved to a different division of your agency or something like that, and then maybe 6 months later, you left the district, the 2-year prohibition would attach from the time when your responsibility ended. So when you left the district, if this ban did apply to you, you would have 18 months left on this particular ban. Next slide, please. Okay, this is DPM 1811.8. A former employee shall be prohibited for 2 years from knowingly representing or aiding, counseling, advising, consulting, or assisting and representing any other person by personal appearance before an agency, a particular matter, blah, blah, blah. Essentially, we call this our behind the scenes rule. And what we're basically saying here is that you, if the other prerequisites for the 2-year ban apply, not only would you be prohibited with regard to your interaction with the district, you'd be prohibited from essentially giving the private sector company that you work for a leg up in counseling them and giving them information with regards to the agency and the matters that you are prohibited from working on. So some people will say, well, hey, I can't talk to the district, but, I always use Google as my default company for whatever reason. I don't know why. I'll just tell Google all how to navigate this project and all who they need to contact at the agency so that they know exactly how to get this done. That's prohibited under this rule. Next slide, please. I told you there's a lot of subsections on the 2-year ban. All right, so this is 1811.9, and it says this section shall be measured from the date of termination of an employee, termination of employment in the employee position held by the former employee when he or she participated personally substantially in the matter. And that's pretty straightforward. That's, again, another time stick to tell you when the clock will start ticking. Next slide, please. All right. So we're on to our third and final post-employment prohibition, and this is the 1-year prohibition. And if you've heard of it before, oftentimes we call it the cooling off period. And it's the shortest prohibition, and it's a little bit different from the first two, the permanent prohibition and the 2-year prohibition, because the permanent prohibition and the 2-year prohibition kind of have to do with the kind of work that, you've done at the agency. So those prohibitions, they attach to you, but only in certain circumstances when you've done particular kinds of work at the agency and you want to kind of potentially come back and try to work on those matters. The difference with the 1-year cooling off period is that it attaches to you no matter what. It doesn't matter what kind of work you've done with the agency. You're just generally prohibited from contacting your agency for a year with the intent to influence the agency. And it doesn't matter if it's about a particular project that you worked on before or if it's about something new. You essentially shouldn't be calling your past agency on behalf of a private sector company with the intent to influence the agency. And there are some exceptions. If you're calling for, factual or perfunctory information that the agency always gives out, you can do that. If you're calling just to say hi, just general or personal greetings or something like that, you can do those kinds of things. But generally, when you're calling to get something done, get the agency to make a decision, get something processed, those kinds of actions would be prohibited under the 1-year cooling off period. I think that's it for the rules. So now we are at the, I dare say, fun part of the presentation.
Ethics is fun.
Right. It is. So now we're at the hypos. There's 4 of them. And so let's get started.
Okay, next slide, please. All right. So we have Mac here. He is, or Caillou, the supervising inspector with DCRA. Recently, Mac was contacted by a real estate company who would like him to work for the company as an inspection consultant. Per the discussed agreement, Mac would work as a consultant for the real estate company for at least 16 hours a week at a rate of $60 per hour. Mac continues inspecting properties in his official position and signing off on inspection reports during his employment discussions with the real estate company. And many of the properties that Mac has inspected during that time are owned by the real estate company. All right, next slide, please. All right. Is there anything else that we want to know before advising MAC or making an assessment of MAC's possible actions here? Or actions?
Feel free to type in the chat if you don't want to unmute yourself and chime in. Are there any questions that you have about the hypothetical before you could make an assessment? Ashley, go back and put the hypo up on the screen again so folks can read it. Yeah. I don't see anything in the chat.
Okay.
Rochelle, is there anything that you...
There's a question in the chat.
Oh, I don't see it.
The question is, when did Mac leave DCRA? Did he inform his employer? That's two different questions.
Okay. So I don't believe Mac left DCRA. Isn't that correct, Asia?
He's not left. He's going to stay at DCRA and have this as outside employment.
Okay. And what was the second question? Ashley, I'm sorry. Can't see him either.
Did he inform his employer?
So did he get advice from anybody or talk to a supervisor? Did someone sign off on this? It's a good question. It's a question I always want to know.
We don't see that he's informed anyone.
But yeah, but something. I agree.
We have one more. Did he have a recusal in place before negotiating / discussing with the potential employer?
Did he do the proper recusal? There's nothing here, but that's an excellent question that you'd want to find out.
So we'll go with what's here, and we don't have that provided here. He did a recusal.
Okay. Okay, those are good questions to get us started. Go to the next. I think it's one more. Oh, yeah. Okay. And then what are the relevant rules implicated? I've heard someone mention recusals and what the rules are about. What else do we? What other rules are implicated here?
We have conflict of interest.
Yeah.
Maybe he flat out refused the offer. It doesn't say.
Okay. Oh, good point. Okay. So is it clear? Okay. So we want to make sure that he actually took the job and is doing it. Conflict of interest. Any others?
That's it.
Okay. Next slide. All right. So I think we have to. Do I click on this page or actually click on? I can't click. All right. Yeah. So we're going to go to the Kahoot on our cell phones and put our pin in, I guess.
Yep. So you all can just go to www.kahoot.it and get ready for Kahoot. We're just going to answer a poll question for this hypothetical. All right. Up on the screen. All right. Oh, there we go. Still got that.
Want to go ahead and start? What do you think?
Yeah, let's go ahead and start.
You want to go ahead and start?
Whenever
Yeah.
you're ready.
I think so. Yeah. That's not good news. All right, we all know about Mac already. So can Mac do this? I guess that's the question. Is Mac allowed to do this? Is that correct, Agent?
So
Yes or no?
I have to answer yes time, so you have about 5 seconds left.
So there's some feedback. So one of you need to either Asia or Rochelle, you need to mute yourself.
Okay, I muted myself. I'm back. I don't hear the feedback anymore. Okay, so 20 of you said no, this is not permissible, and one of you said yes, this is permissible. All right, so Ashley, if you could go back to the presentation and put the hypo back up on the screen.
All right. So, as someone mentioned, there was a question about recusal here. Mac has clearly engaged in negotiating for employment. You see that he discussed an agreement, came to a rate, and the terms and conditions of employment where he works 16 hours per week. And then he continues to inspect properties, and someone asked rightfully, well, who did he tell? Where was his recusal? So there was somewhere in there ethically, that Mac should have done or made a recusal. And then he continued to do his DCRA work and sign off on inspection reports during, discussions, all the while negotiating. So he was violating the conflict of interest rules during then. And then he takes the job potentially, it appears maybe. I don't know, does he take the job, or is it where he takes the job?
Yeah, for purposes hypothetical, going on to it.
Pardon?
Rochelle, you have a lot of feedback. It's very choppy.
Okay. That's better. Yes, for purposes of this hypothetical, Mac ends up taking the job. The important things to note here is that we don't have any information that Mac did a recusal, or that even in the absence of doing a recusal, even though the recusal is an affirmative obligation, it's a part of making sure that you are seeking ethically. Even in the absence of the recusal, he didn't stop working on this real estate company's inspections, which he could have done. If you find yourself before BEGA, though the rules are generally really clear, we're not machines and we're not robots, and we know how to consider mitigating circumstances. So if you're in a situation where you failed to recuse, you forgot, you didn't know, you were unclear about what stage you were at, the very least you could be able to say to us is that even though I failed to formally recuse, and I apologize for that, I didn't work on any of this company stuff. That didn't feel right to me. I stayed away from him. I didn't do that. And Mac just went clean through the stop sign on this one, and he just did what he wanted to do the way he wanted to do it. So I would say that this is absolutely not permissible.
And am I clear? Is this better?
Much better.
So yes, also he went on to then, besides conflict of interest, he continued to make conflict violations. He also violated the outside activity rules because, he was signing off on his own work for a company that, had an interest in that work, financial interest. And so he just commenced a rule breaking there with his outside job. And there could have been a way potentially, or, he could agree that he would never have, if he had gone into this earlier and talked to someone, he could have recused, and they could have been assured that anything involving his company never went to him, potentially. Maybe there could have been some way, unless, he was overseeing all, signing off on all inspections. But there might have been some way for him to do it, but he missed that opportunity. All right. Anything? Oh, you have anything to add, Asia?
No, that's it.
Those of you out there, anything else that you would involve Mac or, talk to, either his supervisor or his colleagues about to give them advice about how to deal with something like this? or prevent it in the future? Okay, well, we'll be coming back to that question as we get to the through these hypos. Ashley, can we go to the next one? All right, here we have Victor, Deputy Mayor of Education, and he has been with the DC government since 2014. He has been facilitating a licensing deal with Google on behalf of the district for the past 18 months. He also recently began employment discussions with Google. Once Victor believed his employment discussions to be serious, he stopped working on the licensing deal. All right, next slide, please. Well, okay, what else might we want to know about what's going on here to determine if Victor's actions are permissible?
Ashley, anything going on in the chat? Feel free to type in any answers. Also, feel free to take yourself off mute and you can verbally give your answer. You have any questions about this hypothetical before you can answer?
We have, oh, sorry.
Can you just put the hypo back up? I'm sorry.
Okay, in the chat we have, did he inform his employer? Is formal recusal required? That's the question. Let's see. What activities did he engage in with Google before getting off the project?
Those are good questions. So with regard to the first question, what did he inform his employer? We're going to go with what we were provided here, and since we were not told here that he informed his employer, then we're going to assume that he did not inform his employer about this. Essentially what it says is the only action that he took is that he stopped working on the licensing bid. And then, what was the second question, Ashley? Is recusal required?
The second question, yes. Is formal recusal required?
I think in this instance, yes, it's required. At some point, he says here, once he believed his employment discussions to be serious. So, at some point, he believed them serious enough that he stopped working. So he recognized, but the question I have, and I think anybody who just see this in the world would say, well, tell us how these employment negotiations arose. Was it in the context of negotiating a deal? Because the next question was, is he off the project? And it's not clear to me from reading this that he's off the project.
I agree with that. It says he stopped working on the deal.
Oh, he did. Oh, sorry.
It says he stopped working on it, but it doesn't say that, anybody at Google knows that his supervisor knows that. What happens when he's called upon to do something regarding the deal? It seems like to me that only Victor knows that he's not working on it right now. And so, I mean, that is the problem with failure to formally recuse yourself in writing. You basically appointed yourself the gatekeeper as to what it is that you will do or won't do regarding a matter. And these are why we have these rules and checks and balances, so that somebody else can shine a light on the things that you're doing or could potentially do, and somebody else can say, well, wait a minute, and, there might be a problem with this, and here's why. And so when you keep it all to yourself, no one can kind of help you and guide you and keep you on the ethical path. So I agree with you, Rochelle. I think recusal is certainly required here, and it does not say that Victor recused himself.
Yeah, and we don't know if he recused himself early enough. We don't know if he worked on things involving Google, and I think that's a question that we would wonder and have to find out about. And going to what Asia mentioned and picking up on this theme of how sensitive it is when you begin seeking, because at some point he's clearly working on the deal, and something happens and then it gets serious. Well, what is that something that happened, and what does that look like to the public? while he's still doing two things at once. There's a clear appearance that he might be trying to leverage his district position to get this job, potentially, or concerned that that could happen. And so by recruiting early, and even if he's not comfortable telling a supervisor, he doesn't want to let someone know he's going to leave, or he's not even sure what to do, or, this is so tentative, he could call Vega or call his ethics counselor or someone, and then they could give him advice on, on minimal recusal, although the best recusals are given to your supervisor or the person that assigned you your work. So, all of that.
You want to go to the question?
Can we go to the question? I think we can answer.
The first one, is there anything we want to know? So I guess the second.
You mean any more questions in the chat?
No, next slide. Next one after this. Here we go. So can anybody tell us which rules apply in this instance? We discussed the DPM. We discussed the seeking and negotiating rule in the DPM. We discussed conflicts of interest rule. We also discussed the federal guidance about recusal and seeking and negotiating. We also discussed the post-employment rules. Can anyone tell me, is there one rule that applies, some, all, which ones?
So we have a clarification as to one of the previous questions. Can you recuse to beggar without telling your supervisor so that you don't endanger your employment if it doesn't work out?
I think it would depend on a lot of factors, but, the way the DPM is written, it talks about financial interests that must be divested and not necessarily directly about the seeking employment. So I think there might be some ambiguity with respect to that. In some situations, I don't think there's any way that you can recuse and not tell someone in your office. And then in others, depending on how much control you have over your own assignments and, sort of how much your work, is done by other people or not uniquely done by you, it might be possible to do that.
I'd say no, because I think the purpose of the recusal is to kind of hand off the reins to someone else so that they can determine how matters that you may have had responsibility for but now are causing you this conflict should be handled. And so there's no one to do that and be the decider, and we are not in a position to say, okay, now this other person in your agency is gonna handle these matters. There needs to be somebody there. I mean, I always say you have to recuse in writing to your superiors, be it your immediate supervisor or somebody maybe further up the chain. But if there's nobody there to kind of take command of that situation and figure out how it's going to be handled with you being walled off from here on out, even though that part is kind of that's not our purview, so it's also kind of not our concern. So I understand what Rochelle is saying from the perspective of, will we come after you and enforce against you if you recuse to us? Probably not, but I would say the better way, or the more proper way to recuse would be to your superior, because then someone has to figure out how is this project going to be handled from here on out without this person involved, with this person walled off, which they do not have the opportunity to do if you're trying to keep it from them and just coming to us. But, every situation is different. So I guess kind of in certain circumstances, yes, like what Rochelle said, but I would always encourage you to do it directly with your superiors.
Yeah, that's best practice, without a doubt. So I want to echo that. But under the law, if you don't engage in any action, i.e. you refrain, that could in some instances be enough to recuse. I think, again, the prudent way to do a recusal is to do it formally. And so that way, again, it removes any shadow of a doubt about, sort of you making it clear that you would not, because sometimes your recusal, you might think, well, this isn't really a problem. That thing, that's last year's news. That's an old matter, but things rear their heads. You never know. And so that's another thing, you know, again, that kind of more formal recusal, while, again, it's a sensitive topic, is more protective of you and your agency. And so that's what I recommend. All right, anything else on this one?
No.
Oh, yeah.
We have two comments that state that the conflict of interest rule are relevant. And then we have a question, what about the criminal statute?
With respect to the criminal statute for him, that's a big question we have to ask ourselves. And so the conflict of interest rules are relevant, and the criminal statute for him, I'm not even clear if, assuming, and I think the typo leads me to this assumption, he was working on this licensing deal while also beginning to talk. I think we need to get to what serious discussions mean. And does he understand the distinction between seeking and negotiating, going back to how we started? And so if the initial discussion was, I can't think of his name now, Doug, I don't know, I'm making something up, whatever his name was. Victor. If Victor, it was simply, he had sent a resume over there at some point through the normal course and got a call back, that's clearly seeking, right? But if Victor began, which often happens, especially when people work close together or are very senior, we like to say here at OGE, they begin very close to the goal line. People don't call you up and, it's usually not you send out 50 resumes or one resume and someone calls you. It's either a headhunter or someone on the team reaches out and says, we think this is a really great fit. They've watched you work, or vice versa. You see a place for yourself. Either way, it's very, you have a cozy now relationship that came and developed out of your work together in the district. And so we'd want to be assured that he had not entered into that mutual area of discussions where they were working mutually towards the terms and conditions of employment and working towards an agreement. And so it's working towards the agreement or actually having the agreement would violate 208. Merely being at the, we'd love for you to come over, and he didn't say no, but that's it. Or the, I sent something out there generally, not to the person, because I think we'd all have a problem with, using your position for a private gain if it was done in any way in the context or in the middle of the work on the deal, which is a question you want to ask too, I think.
Yeah, I agree with you. I'd say we would, if we were looking at this, we would certainly want to know. It says once he believes his discussions to be serious, he stopped working on the matter. So we would kind of want to know what happened in that gray area, what happened before he believed them to be serious. So we would kind of do our own fact gathering and figure out what exactly took place, on what dates, and determine where he was. Was he just preliminarily interested? Was he seeking? Was he negotiating? And compare that with the date that he ceased doing work on the matter, and then kind of analyze everything and see what territory we were in. You're on mute.
Right. I think the next typo, unification.
Sure.
Okay.
Go to the next typo. We don't need to do the Kahoot for this one because we kind of discussed it at length, and the answer is.
Oh, sorry. I agree.
This is not permissible. We would have preferred for Victor to formally recuse, but it is a very good thing that he stopped doing work on the matter at some point. But we would probably have to do further investigation. The preference is always going to be for him to have recused himself formally in writing and cease work on the matter. Okay, hypo number 3. The General Counsel for the Department of Behavioral Health contacted our office because the agency would like to bring back a previous employee, Tricia, as a contractor. Tricia left the agency on April 6, 2020. That's really recent. Tricia developed community outreach programs as a DBH employee, and the agency would like her to continue her work on a part-time contractual basis. Next slide, Ashley. All right. Is there anything else we want to know about this before we consider whether the agency can bring back Tricia? Let us know in the chat. Anything in the chat yet, Ashley?
Yes, we have one. When she left, is she working with an agency doing work with DBH? I guess that's two questions. When did she leave, and is she working with an agency that does business with DBH?
Okay. Can the person who submitted the question clarify? Are you asking is she now working for a company that does business with DBH now that she left? And to answer the question, I believe, Ashley, if you don't mind going back to the hypo, I believe she left the agency on April 6th, 2020. So I just need clarity on that second part of the question. Because I think that was a good question.
Let's see. Is she now working for a company doing business with DBH?
Okay, that's a good question. So to answer the question, we'll just go with what's in the hypo, and that has not been provided here. So we're going to assume that Trisha is just out on her own, and they want to contract with her directly. I see a comment from Glenn Dubin. Is she working as an independent contractor with a firm? That's kind of the same question. So for our purposes, we'll assume that she's an independent contractor. Really good question.
Okay. We also have, did she work on matters related to what she would be doing?
Not only does she work on matters related to what she will be doing, she's going to be working on the exact same stuff. Same exact projects, doing her same exact job, but just on a part-time contractual basis. Is that...
Next question is, does she work with or have any financial interest in any of the outreach programs?
So I'm going to try to interpret that question. I guess the question is she representing a third party, essentially, other than the district? Is that what we're asking? Is she invested in one of the programs or something like that?
I don't have a clarity. Yes, she said yes. That's what she's asking.
So we'll just assume that Trisha is out on her own. She's not working for any third party, and she's not financially invested in any of the programs.
Okay, and the last question is, will she be in a position to influence dealings with DBH and the outreach program?
Yes. She will be. All right, let's move to I guess it's the second red slide. We answered the questions. There we go. So for this hypothetical, which of the relevant rules do we think are implicated? We discussed seeking employment, negotiating for employment, conflict of interest, post-employment. Which of those rules do we think apply? And if you think it's post-employment, there's 3 general prohibitions. There's the permanent ban, the 2-year ban, and the 1-year cooling off period. So if you think that post-employment is one of the rules that would be relevant here, tell me which of those bans do you think would apply?
We don't have anything in the chat.
All right. For the sake of time.
Oh, wait, one just popped up.
Okay.
Okay, I think none, because she is continuing to work for the interests of the agency, and then we have none. So that's two answers that we received. And one more. Post-employment rule behind the scenes. So that's the 2 year.
Okay. 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 Somebody said none, and somebody said post-employment rule, the 2 year behind the scenes. Okay, so those are good perspectives. Let's go to the Kahoot and do the poll really quickly on this one, and then we'll discuss the answers. You're gonna have to skip the second one. It's the third one. All right, if everybody could go to kahoot.it and let me know whether you think the agency would is able to allow Tricia to come back under the circumstances we discussed. All right, 13 of you said yes, Tricia can come back, and 2 of you said no, Tricia may not come back. Any of the yes people, can you put in the chat and tell me why you said yes? Why is this permissible? Any comments in the chat yet, Ashley?
No.
All right, so we have one more hypo to get to. I don't know if we'll get to it or not, but
We have one that just popped up. DC can waive conflict is one, and the second one is there doesn't appear to be any conflict of interest.
Okay. Okay. Both of those comments, well, not necessarily the word that was used, but both of those comments are actually correct. So this hypothetical was sort of a trick question. Some of you may have done this before if you are a general counsel, ethics counselor, or somebody that works on contracts. You may know that first, I'll say the post-employment restrictions attached to the past employee and not to the agency. So we do have an exception in the post-employment rules that we've carved out, and it essentially says that an agency can bring back a past employee, and if they do properly bring back the past employee to work under a contract, that employee can then work on whatever matters the agency wants them to work on. But certain elements have to be met in order for the agency to be able to properly bring that person back. The first one is that the employee represents the district's interests only. That means that there's no third party. As we said, Tricia doesn't work for anybody. She's just an independent contractor. Number two, the employee's interests are in line with the district's interests. And if, Tricia's coming back to further these community outreach programs, and that is what the district wants her to do. I didn't read anything in a hypothetical that would lead us to believe that their interests are conflicting or not aligned. And the third one is that the employee is working on behalf of the agency only, and the agency and the employee must enter into a written agreement which expressly states that the employee is representing the interests of the district only. And once that written agreement is executed, then that employee is free to work on, whatever projects they want to. There's also one caveat that I know many people hate, and that is that the employee is prohibited from negotiating the terms of the contract directly with the agency. So they essentially have to assign an intermediary to do that. Many people hire an attorney, but it could be anybody that the person wanted to assign. But you're prohibited from talking directly to the agency about the terms of the contract. If the agency presents you with the contract, you don't want to change it at all, you can go ahead and sign it, and you don't need an intermediary. But if you want to negotiate and change some things, maybe get some more money or change the terms or something like that, you need to assign somebody to do that on your behalf. But if that is done and it's done properly, then the agency is free to bring back a past employee, regardless of any of the post-employment prohibitions. They're free to bring that person back on a contractual basis. And that's it. So we are over the time limit. We had another hypo, but we'll end it here. Any of these materials that you want, PowerPoint, I also have it in a Word document format. You are welcome to have, and I guess Ash kind of tell you how you can get documents. But thanks for joining us. I hope that it's been informative and helpful. Let me go down, and we have some quick tips for negotiating for employment and post-employment, and I'll go through those really quickly, and then we'll wrap it up. Ashley, can you head down to the quick tips? All right. So let's go over these. Rochelle, did you want to do these, or you want me to do them?
You're free to do them. Thank you.
All right. So these are just some quick tips about negotiating for employment and post-employment. The first thing is when you're seeking or negotiating employment with a private sector company, recuse yourself in writing as soon as possible. I know that people do not like to hear this, but in the long run, it's better that you cover yourself and that you're transitioned ethically, especially when you want to go and work for a private sector company that does business with your agency. So I know people don't want to show their hand and they don't want their bosses to know that they're looking for another job. I completely get it, but if you could just, look into the future, you'd much rather have covered yourself and maybe showed your hand, even if you don't end up taking the job, than be facing an ethics violation, because then you may become, unmarketable. Maybe the private sector company doesn't want you anymore because you're not ethical and you're having these issues with Vega. So there's all kinds of things that could arise, and it could ultimately end up tarnishing your professional reputation. So we just encourage you to take those proper ethical steps. Number two, if you are confused about whether you are negotiating or whether you're seeking or negotiating or neither or both, if you have any confusion about these matters, contact us. If you want to contact us first, that's perfectly fine, and talk to us, and then, through our analysis and our discussion with you, you can kind of determine when you need to pull in your supervisor and start discussing these things with your agency. Number three, the district's post-employment restrictions only apply to the private sector. This is an important one. If you're transitioning to federal government or government work in another jurisdiction, you need not adhere to the post-employment rules. If you're going from government work to government work, the post-employment rules don't apply. This is only for private sector companies, particular law firms, the Googles and Amazons and stuff like that. Number four, the post-employment rules are complicated. Call us for assistance when in doubt. Call us for assistance even when you're 100% sure, because you may still be wrong. So call us. Number five, the post-employment rules apply to the past employee, not the company. Your new employer will not be restricted if they hire you, except, of course, they won't be, able to assign you to work on certain matters if you worked on those matters and the post-employment restrictions apply to you, then they wouldn't be able to assign you to those matters. But other than that, there's no restrictions on the company. And in fact, that's not even a restriction on the company, it's just a restriction on you. But if they want to, avoid you potentially taking on ethical liability, they wouldn't assign you to those matters, but they could assign you to those matters. But it will be up to you to know the rules and not do anything that will violate the post-employment rules. Number six, you are entitled to free post-employment advice forever. Because we have that permanent prohibition, we are obligated to provide you with post-employment advice forever. You can call us 1 year after you leave, 5 years after you leave, 25 years after you leave. I've not gotten anybody called 25 years, but I had got somebody, I think he was 6 or 7 years out or something like that, and he called us up. But you can call us forever for post-employment advice. Number seven, there are exceptions to the post-employment rules, including one that allows the agency to bring back a past employee on a contract. We discussed that one on the last hypothetical. There are rules surrounding this as well. Of course, restrictions. We discussed the restrictions on the hypothetical. but call us for guidance, even if you're representing the agency or if you are the outside employee. I'm sorry, the past employee. Give us a call and we'll walk you through it. I think that's it. Anything to add, Rochelle? Okay.
No, not at all. I think you did a great job. Thank you.
All right, that's it. Thanks for joining us.
Thank you for your time. Have a great day. Bye.